big, bad ass number, 229 million, which I believe is the largest medical malpractice verdict in the history of the United States. And that was Keith's case. Welcome to episode 1 of the Law by Number podcast, where we are going to look at the numbers that make the best law firms tick. And I really am super excited, not just to be starting this podcast, but to have Keith Forman on today. Keith is a partner at Wais, Vogelstein, Forman, Koch, and Norman. Keith is a baller. I should probably introduce myself. I'm Byron Warnken. I'm the host of the podcast. But I'm really excited to have Keith on. I've known Keith a long time. Keith is an excellent co-counsel partner. We've done a number of cases together. Great attorney. Welcome, Keith.
Great to be here.
So, Keith, I have you as handling exclusively plaintiff's medical malpractice, and most of that being birth injury. Is that accurate?
That is accurate. Good description.
Cool. So Keith has a number of 8 and 9-figure verdicts. So that's something that the watchers of this or listeners of this podcast should know. And I wanted to start out in that it's law by number, right? I wanted to start out with a big, bad ass number. And that's 229 million, as in $229 million, which I believe is the largest medical malpractice verdict in the history of the United States. And that was Keith's case. Keith, is that accurate, that it's the largest?
Upon information and belief. We've done a little research. Nothing in a single injury case. Obviously, there's some class action things that.
Sure.
Things like that. Single injury case, largest verdict in the history of the country.
Wow. Can you take a minute or two just to tell us a little bit about the case? It was you, Mary Cook, Sarah Smith was the trial team. Is that right?
That's right. That's right.
Yep.
Seems like a lifetime ago now. Global pandemic, things of that nature.
That's right. When was the verdict in this case?
July of 2019, July 1st, 2019.
Wow. Okay.
So it goes way back.
Take a minute just to tell us about the case, if you would.
Very memorable case. Young mother, immigrant from another country, comes over here, Liberia. She's got some complications. She's got some adoptive parents who are helping her with her medical care. Kind of surprised when she gets here. They find out she's pregnant. She develops a condition called preeclampsia. At the time, she's living in Southern Maryland. They ship her over to Hopkins Bayview, and the wheels come off the bus while she's there. They mislead her was the theme of the case. Through their words and their actions, they really misled mom into thinking that the situation with her baby was catastrophically bad, that it was almost a guarantee the baby was going to be born with brain damage. All that was inaccurate. And it led to a decision-making process, which resulted in the child being harmed in utero, a very severe injury, cerebral palsy, lifetime of care.
Got it. And I remember you telling me about the closing in that case, and it seemed like the closing had really inflamed the jury a little bit. Is that right?
Yeah, I mean, I think a lot of times we get into these trials and the defense and the plaintiff start trying two different cases, and one side only sees their case. And I really think that's what was going on in this case. I think the defense was only seeing their case. And we could tell during the trial, you see the jury members, sometimes they're misleading you, they're playing poker, but the jury in this case was pretty transparent about how they were feeling about the defense. And we leaned into it. It was based on the evidence. We leaned into the fact that words matter. That was the theme of my closing, and that the words of these healthcare providers who were in a superior and dominant position to that of a 16-year-old girl who was recently came over from Liberia, and they misled her, and the jury got it. And when the defense got up and gave their closing, again, I had this reaction. Have they been watching the trial that we've been trying for the past, 2.5 weeks? Because I'm not so sure they did. And at times the jury was looking at the lawyer giving closing, with sort of confused look, like that's not the evidence, and that's not the case, and that's not the trial. And so I think the jury got it.
And it was clearly the jury's intent that they wanted that child taken care of financially for the rest of the child's life.
No question.
Right. So I had a marketing thought, because I was Googling this in preparation for this morning, and I'm looking at these lists of largest verdicts, and there are quite a few lists and quite a few that do not have this verdict on them. So I think if you have your people reach out to the curators of these lists and say, hey, you missed one, let me show you this verdict, send a link back to the Wais Vogelstein Forman website. So
that's not a bad idea. We've thought about, and maybe some of the viewers know this or not, the case ended poorly on appeal. It was a real travesty of justice as far as we're concerned, but the case still lives and will always live. And we've contemplated, and we own a website domain, we've contemplated starting a website that just focuses on the case. It was all a matter of public record and really highlighting to the public what went wrong. The case is kind of a microcosm of what's wrong, not only with medicine, but what's wrong with the judiciary and a lot of the injustices that take place in the judicial context. So that's something that's in the works. I know the verdict is on some lists, but it's not a bad idea. We can reach out to those people.
Yeah, a couple of the top ranking lists, if you will, didn't have it, and I was surprised, and I wanted to reach out myself.
We're humble. You talk about numbers, and that's a big one, and I'm certainly proud of that case. But you take the cumulative result, and I can't help it. I keep a list. A case settles, I just write down the last name. If it's over a $3 million settlement, I write down the last name. It's an old piece of paper that I've had running now for 10 years.
Wow.
It's just this disgusting piece of paper. I could actually grab it right now.
That's incredible. Yeah.
And you cumulatively, in 15 years, I think I'm got 62 or 63 settlements above 3 million, and a lot of those for a lot more. And
wow,
life changing for those families. It's amazing. We keep in touch with our clients, and it's great to hear developments, kids doing well. The defense is always saying our clients are going to die tomorrow. And so when you see them doing great in physical therapy and they get this new equipment that they wouldn't have been able to have outside of our litigation, it's really rewarding.
Absolutely. That's really cool. And it brings up a point for me, because I've been, watching this, from the outside, that you've had like a very almost accelerated career, right? Because it seems like you've had 2 or 3 careers all just in like 15 years with this, with some of the results and the amount of good that you've been able to do, you and your firm collectively. So when you started with Gary Wais and Ken Vogelstein, how many attorneys were there at the time?
I was number 4. At the time, there were 3 lawyers, Gary, Kenny, another lawyer. They were all partners. I came in as the sole associate. So we had about 13 or 1,400 square feet, 4 lawyers, I think 3 staff people. And my father-in-law asked me this question all the time, how big are you now? And I've kind of been the one constant, so I am proud of that. And so we've got something like 20 lawyers now in 2 states.
Yep.
20 staff people.
And this was like 12 years ago when you, is that right?
I started with the firm in June of 2009.
Okay. So a question that I have, and I had you guys are growing too fast for your own website. I had you at 17 lawyers, which is a huge number in a contingency fee only practice. And it brought up a question for me, right? So you were there when it was 4 attorneys. Now it's 17. is it easier or harder to manage, because the way I think about my, my firm, right? We have 6 attorneys, and it's constantly trying to balance supply and demand, right? Like, and because of my background in marketing, we're heavy supply, which, heavy demand, which is good, but like, supply of good quality lawyers to work it, that's something that, it is a, I don't know that I'd call it a struggle, but, it's just this constant push pull of this. And I'm sure you've felt that as you've grown, but as somebody with 6 attorneys looking at somebody who's with 17 attorneys, is it easier or harder to manage the connection of supply and demand with more lawyers? Does that make sense? Long question, poorly worded, but.
Yeah, it definitely does. And that's why the most important number for me is, what do we have of quality that we're investigating? We've got the cases in litigation, our reputation, our hard work. I've got an incredible team in both states and in the practice we do in Minnesota and Texas and elsewhere. The cases, in a lot of ways, once they're in litigation, we know we're going to do a great job, statistically, overwhelmingly likely to get a great result for our client. A lot of landmines, a lot of hard work, but that's the way it happens.
Yep.
But we've got to make sure that the pipeline, it's kind of a hokey word, but we got to make sure the pipeline is there. And we're blessed in that regard. But it's a challenge because, as you know, you get a 3 or 4 month lull for whatever reason. You can't identify what's going on. You've got cases out to the teams in my office. We're a team-oriented practice. And because of a trial or a big hearing somewhere, a case that I wanted filed, say in February, gets filed in April. Well, that impacts things as you get into fiscal years and things like that. And it's very hard to predict. So definitely a challenge as we've grown, but it's kind of the same challenge, thankfully, multiplied. We've never hit the point where I've had to say, wow, we're bloated and we don't have the work. It's always a huge concern, but blessed in that regard in terms of the volume of quality cases that we're asked to investigate and pursue.
Yeah, that makes sense. And that's, I guess that's, the same challenge multiplied, is I think probably a good way to put it. So let's come to some of these specific numbers. In terms of the numbers that you are looking at for the health of your firm, you mentioned pipeline. So is that sort of aggregate number of new investigations?
Yeah, we've gotten to the point now where being selective is probably an understatement. We just have the ability to make sure that it's the right case in the right jurisdiction, even with the right clients. And I say that very delicately, but sometimes lawyers and clients, or a law firm and clients, they just don't mesh. And even identifying that is really important. Taking a case where the marriage between client and lawyer isn't going to work is something that's important for us to identify, even if the case sounds like a great case that could result in a big settlement. We don't want to find ourselves fighting with clients or being in a situation where they're unhappy with us. So identifying those cases is important as well.
Understood.
So we have this ability to keep our investigation case list sort of depressed for us, but in a range where I can forecast who's getting what case and when, depending on when cases fall out. Obviously, COVID has made these things a little more complicated.
Sure.
But we've got targets that we have in mind, and keeping that number where it is important.
When you say targets, without necessarily even getting into some of the specific numbers of those targets, what are we talking? Number of cases being filed, number of expert opinions? I mean, what kind of targets are we talking about?
So the targets we're talking about, and I think an easy way to think about it is this, and I don't think there are any secrets here for the most part. With the way our teams are divided, I really don't want any one lawyer working on more than 5 or 6 of these cases at a time. They're highly collaborative. And so we look at it through that lens in relation to trial dates, right? Because old adage, trial date equals payday, or at least some sort of resolution or conclusion.
Sure.
That's really the most important number, aside from what's in the pipeline, is what are the trial dates? And it's not even so much what do we have filed, because a lot of times in jurisdictions you file, you don't get a trial date for 2 years.
Right.
So we look at it through the lens of what's sort of the maximum caseload a lawyer can work with through the number of actual trial dates we have, when those cases are likely to resolve, and when to reload. And so if you do the math in terms of the number of lawyers we do have to have something like 60 or 70 cases sort of simmering at various levels in order to satisfy when a case settles, a new case comes in.
Makes sense. So when we talk 60 or 70 cases, we obviously mean litigation, cases in litigation. And it sounds like you're also referring to something, a pre-litigation, but something post sort of broad investigation. Am I hearing that right?
I think that's a good way to put it.
Yeah. So, what is that delineation line, if you will, where it's like, okay, well, this is an investigation. No. This is pre-lit, if you will. Is that, I don't know if that question is well framed, but
I think it's actually, I know exactly what you're getting at. So I don't want to be spending a lot of time and money on cases that ultimately just not going to happen.
Mm-hmm.
And so we've just gotten very astute at only really opening a file and ordering records on cases that we feel supremely confident are going to end up in litigation. Now, that's not we don't bat 100% on that.
Sure.
I mean, look, I wish we did, but we don't. But we've gotten very good at lowering the number of cases we retain, investigate, and reject. And that's just through years of experience. All of our lawyers, this isn't really a paralegal function that we dedicate paralegals to, like other law firms. And that process works for some firms. The lawyers figure out really before we even decide to sign a case, whether it's a case. And you can tell, a large percentage of the time you can tell.
Something I said earlier, where you've had this sort of accelerated career, in my view. I mean, I think that there's probably there's clearly some sort of special skill there, right? Is it? Am I overstating?
It's really just luck.
And so there's a lot of modesty in that, and I get it. And any good career, right, is going to have some luck, right? Like,
sure.
Luck is clearly part of anybody's good trajectory, I think. And I think I've heard you say it before that, it's, you get lucky through being out there and hard work and et cetera.
It's just when hard work and opportunity meet.
All right, there you go.
The luck comes in.
But I think that there's something about seeing the case, as it comes in, where is that something that you sort of prided yourself on? Is that something that you've taught to some of the others at the firm? And am I overstating that to say that you have a special skill in case identification?
It's something I pride myself in.
Mm-hmm.
I mean, I try not to let my head get too big on it, but I do sort of have this innate ability to see a case in some ways from beginning to end the second I see an intake.
Right.
We have a case that we mediated 8 days ago that I literally read the intake. I said, this is where I want the case to go in my head. Called my associate. We've litigated it for 14 months now, and we're close to the finish line.
Got it.
And I don't know, I would call it a special skill. I do think I have an innate ability to do it for whatever reason. It's something that's inside me for sure.
Sure. So is some of the background on that just a lot of time spent in the medicine on birth injury?
Yeah, I think I picked it up very quickly.
Mm-hmm.
I just think I don't know, a lot of people who know me, my brother's a physician. My dad had a lot of interest in medicine, even though he didn't practice. And for whatever reason I have a keen sense of picking up medicine, and particularly in the birth injury realm, I've I have a natural ability for it, I think, and I've dedicated myself to continuing to learn. People laugh when I tell them that my Twitter account, in terms of the things I follow, is like 1/3 sports, 1/3 music, 1/3 medical journals and medical accounts, covering the New England Journal of Medicine and obstetrical manuals. And I do, when they tweet new information, I probably read it more than the physicians do. I don't say that in jest, but I just want to know. I find it interesting. And if there are advances in terms of the change in a standard of care, I want to know about it, because that's another way where I can look at a case where maybe one of my colleagues isn't familiar with this change in the standard of care. And I look at the case and I say, well, 5 years ago, that wouldn't have been a case, but today it is, and I'm taking it. And I know that because there's been this change, because I follow the medicine.
So 1/3 sports, 1/3 music, 1/3 medicine. I got to think Antonio Brown came up on your feed a lot. It's sort of the perfect storm of all three.
Without question.
So something else that I didn't know until I was reading your bio today. You work, because I thought you were defense prior to Wais, which you were.
I was
right.
Yeah.
And I didn't realize that you had experience on the plaintiff side prior to that.
True.
Got it.
So, I mean, I started out at what I think was and still is a preeminent firm that does birth injury work. And I guess it goes to this, I've never heard anybody say accelerated career. I did make a joke recently on a Zoom call with a client about the grayness in my hair, which is like a joke my father would have made. So I guess I am getting older. But we had this firm I was at, and as a baby lawyer, they threw me to the wolves, and I managed to fight them off pretty good. Got
it. Yeah. I didn't know that until this morning. You guys do birth injury in a lot of different jurisdictions around the country. Is that correct?
Yep.
Yeah. And you've opened it. At some point in this 12-year career with Wais, you've opened a second office.
Correct. So we have an office that we opened in Chicago, and we've got what I'll call sort of a shadow office in Minnesota.
Gotcha. In terms of Chicago, what are the challenges in opening that second office that is a plane ride away?
Besides doing it during a global pandemic, the timing was difficult. The challenges have been somewhat predictable. I think about how I would feel if someone I know who does what we do nationally opened an office in Baltimore. So if someone in Chicago opened an office here, I know I'd feel a little bit threatened and a little bit annoyed. A lot of lay people or ordinary people don't really think about these things. There isn't an unlimited number of the type of cases we're working on. It's a finite number, and there is competition. All the firms want all the best cases. And so I thought about that before we even opened the office. How would I feel? And we already had relationships with some lawyers and some law firms in Chicago. So before we even opened the office, I made some calls, spoke to some people I would call friends, let them know that it wasn't personal, that we want to develop relationships and make things as smooth as can be. And I think it was well received. There have been issues with not wanting to step on people's toes, developing referral relationships in an area where people don't know us well. But one of the benefits is having a national reputation, for sure. So when we go in and talk to a firm that does get a lot of these cases, who may be looking to refer them or whatever it might be, when we say we're the firm that got the $229 million verdict, there's mileage there. And that has certainly helped. But it's kind of the don't blank where you eat kind of challenge. And then the other part of it is, not knowing the bench really well. And that's why our managing partner out there, John Lamontia, was such a great hire for us. He's been practicing out there for 20 plus years, knows a lot of the bench in Cook County, and that has helped in that realm as well.
So what percentage of your cases are Maryland versus other jurisdictions?
Right now, last time I looked, I did the math. This was about 18 days ago. It was about 40% in Maryland. So actually the majority of our practice now is now out of state.
Got it. And I think I asked you that once before, maybe 3 or 4 years ago. And I want to say it was 60-40 the other way, 60-40 Maryland, I think.
Yeah, that middle percentage has flipped.
Got it. Yeah, that makes sense. How many, so I know you said that you don't have a lot of rejections, right? Or you don't have a lot of investigations that don't proceed to that next phase. But and you did say you don't bat 1,000 because of course you don't.
Nobody does.
Right, exactly. I mean, how many cases, somebody who doesn't really do a ton of med mal, but maybe gets some med mal, how many med mal cases are you looking at to find the one you're taking?
Probably 1,000.
That high? Wow.
Yeah. I mean, it's a lot. It's a
Sure.
lot. I mean, if you're talking about the whole spectrum, you know, we were looking at it sort of a micro level. I mean, during the day, office hours 9 to 5, you know, we probably average 2 leads an hour.
Mm-hmm.
And I mean, and specifically in medical malpractice cases. And so, you know, if you do the math on that, it adds up very quickly in the number of leads that come in that ultimately we're not able to help those clients.
Sure. Yeah. And I think there's a problem. I don't know whether it's a problem in Maryland, problem nationwide, whatever, in sort of the run of the mill med mal, you know, and it's a funny way to say that, run of the mill med mal, but you know, that sort of that case that is worth $500,000, million and a half, whatever, finding good attorneys to take that. I mean, there's just not a lot of that, unfortunately. I think it's a hole in the system in some ways.
It has been one of the successes. I completely agree. We've had this discussion. It has been one of the successes of tort reform. So if you take on aggregate the tort reform laws all over the country, they have washed out in a lot of ways that, like you said, $500,000 to $1 million medical malpractice case. They have become either impossible to litigate because of the law. An example being in Texas, emergency room cases, you have to prove by clear and convincing gross negligence standards. And then there's a cap on top of it. So you're not going to spend $50,000 or $100,000 to get a $250,000 settlement. It makes no sense. So that's one really good example. And then, you know, you get caps in other jurisdictions on wrongful death claims, things like that, or whatever non-economic damages may be applicable to a case. And it depresses, it's sad. I mean, it's really an access to the courts type of thing. It really depresses the ability of lawyers to take those cases. And then certain jurisdictions, you get into these really insulting fee issues. Like in New Jersey, it's a sliding scale that starts at like 10%. And, you know, there can be a general perception that lawyers get, you know, too much, but when you factor in the risk of litigating these cases, it's, you know, you tell people auto accident case, the lawyer gets a third. You know, the med mal case, lawyers typically get 40%, but we spend, it's no secret, to litigate a birth injury case from beginning to end is going to cost between $100,000 and $300,000.
Right.
And when you take on that sort of risk, you know, the price goes up. But
yeah, I don't think people realize how much less safe the medical setting has been made by tort reform. I mean, people like you, people like me, people who do what we do, they understand. And I think even the doctors lobby inherently understands that the incentives aren't matching. But it is what it is. And this is this train that has gone this far down the tracks. And I mean, how do we turn that around if we do? I mean, I don't, I don't know where that goes from here.
Yeah, I don't know either. It's really sad. And this is a little bit of a tangent here. Obviously my brother's a healthcare provider. I'm friends with a lot of healthcare providers. I
Yep.
believe in the wonders of medicine. I have had my own ailments. I do not, as a broad philosophy, believe medical care is bad. I think the obstetrical community has particular issues in their ability to recognize their own faults throughout the years. It's a somewhat unique problem to obstetrics. But I was saying lately to people who will listen, it's really frightening because I actually think medical care has gotten worse. As a whole, I do think medical care has gotten worse, and I don't know what the root cause is, but it's sad. I mean, and I think some of it is due to tort reform. Obviously, there's a lot of politics involved in medicine, and it's a business, so that impacts it too. But it'd be nice to fix both problems: medical care be better, and the ability of people to bring claims to be better. There's always been this idea that those things cannot live together. They're mutually exclusive, and I completely disagree with that philosophy.
Right. Yeah, I'm with you. I think you're definitely preaching to the choir on that one. Turning back to numbers a little bit. So pipeline is one of your main numbers. If you could have 3 numbers only to identify the health of your business, with one of them being pipeline, or new investigations, if you will, what are the other 2 numbers?
Yeah, so I alluded to that a little bit. The other number would be trial dates.
Oh, okay.
I mean, for sure. I mean, we keep a trial calendar, nothing fancy. It's an Excel spreadsheet, and this will answer your question. It's really 2 numbers. It's trial dates and mediation dates. So if we don't have trial dates and we don't have mediation dates, given the size of the firm and the volume we handle, something is broken. So both of those things need to be there. So and I would rank them, this sort of pre-suit investigation list of cases that we have to reload as the number one important factor. That's the number one number. Number 2 is the trial dates and the volume of them being concordant with the number of lawyers we have working on cases. And third, the mediation dates. So I know that with the trials lurking, we've got cases being mediated. And there has been, again, another old adage, or I referenced it earlier, this idea that trial dates are paydays. There has been a little bit of a shift in terms of how insurance companies and hospitals view their cases, these high stake cases. I think there's been somewhat of a recognition that attempting earlier resolution is a financially beneficial approach. So sometimes we have mediation dates in cases that we haven't even filed, and we have mediation dates in cases that don't have a trial date. So they don't always line up, but those 3 numbers, that pre-suit investigation list, trial dates, mediation dates.
Got it. What % of your firm's practice, not yours in particular, but the firm as a whole, is birth injury?
95%.
Wow. That's crept up over time.
Yes.
As I guess one might expect.
Yes.
As the sort of subspecialty.
And when we say birth injury, and you and I have had this discussion, it's kind of a junk term. I think it's a term of art, obviously important marketing term, but we don't necessarily think about it as birth injury. When people say, "What do you do?" depending on my audience, right? I'm a lawyer. Well, what kind of lawyer are you? I'm a litigator.
Right,
and then I say,
right.
are you a physician? No. Oh, okay, I'm a medical malpractice lawyer. Right? I sue doctors, right? When we have this discussion, if it gets down, we start peeling the layers of that onion of what does Keith do. I say I'm a child injury lawyer because I represent children who are harmed through medical care. Some of it, a significant percentage, is birth related. A lot of it is also neonatal and pediatric related. So it's not just birth.
what percentage of your cases are ultimately a cerebral palsy case?
Probably 80%.
Got it.
The advances in medicine have changed that number. Not to get too detailed into the medicine, but for babies who are asphyxiated, going back to around 2010, there was the advent of what's called hypothermia treatment for asphyxiated newborns, or whole body cooling.
Mm-hmm.
And what that does is it avoids what's called the reperfusion injury, when you've suffered a lack of oxygen to your vital organs, including your brain. And it's been a wonderful advance in science. And clients who I represent today, who I could probably say for sure would have something like spastic cerebral palsy in 1, 2, 3, or 4 limbs, now have a much different presentation when they're cooled. Their injuries manifest differently. They may, and often do, end up with severe developmental delay and disabilities, but may not have a diagnosis of cerebral palsy. So that technology, medically in particular, has skewed that number. Whereas 10, 15 years ago, it was probably 100% of anybody doing a child injury case was only doing it for a child who had an injury like cerebral palsy.
Interesting. My reading on whole body cooling is I think a little more muted that the results than you're saying. So it's interesting to hear that, because things I read say, oh, it works in maybe 10 to 20% of cases. And I think what is being lost in that is there's a spectrum of what it means to work, I guess.
Right,
am I hearing that? Yeah.
Yeah, I mean, it's definitely, I mean, and I don't know if even the medical community has adequately defined working. And here's the problem, and we get into this debate a lot in litigation. What exactly is a moderate disability? What is a severe disability? What's a mild disability? This really comes up a lot in the context of cases involving a preterm infant and trying to forecast at a certain gestational age the degree of disability. And when you don't have a common definition, either by choice, sometimes there's politics in that, or you don't have a common definition by just the nature of the subject, that makes defining the efficacy of something difficult. Ergo whole body cooling being something that's hard to really quantify its efficacy. But I just feel anecdotally, from my perspective, I see kids in the records in these cases born just in terrible shape, nearly dead. And I just know from 15 years ago, 10 years ago, those kids without cooling were almost universally diagnosed with spastic, usually quadriplegic cerebral palsy. And a significant percentage of kids like that now either have a very mild cerebral palsy or no cerebral palsy, but still have significant lifelong delays. It's a different challenge than raising a child who may unfortunately be confined to a wheelchair and need feeding assistance. There are behavioral issues that can be very difficult for a child who's been asphyxiated and has been cooled, ADHD, even connected to autism, different sort of challenges, still a lifelong struggle for the affected children and their families.
Yeah, it's interesting, how we're pretty deep in the weeds here. And I think there's a lot. No, it's great. I mean, this is important stuff. And I think that there's a lot of people out there who are, claim to be birth injury attorneys who aren't in these weeds. And I'm even talking about some people who are actually prosecuting the case, not just saying, okay, well, I'm going to refer it to somebody like Keith. I mean, and I think that that's pretty dangerous. So I really think that there's a need for people in the subspecialty. There's a need for this weeds, to be down in this weeds. One of the things, so you said birth injury is an important marketing term. So I did quite a bit of research, actually, because we are in the process of building out our network of the best birth injury attorneys in the country. And in the process of our research, we changed, we pivoted and said, we are building out the network of the best cerebral palsy lawyers in the country. So I think that I'm not sure that people are getting that right. And this is
I don't know. This is like one of those things is, how exact is the science on this? And I actually think, you and I have had this discussion before. It may actually be, there may be some regionality to it.
That's a good point. Yep.
It's and how medical providers talk to people. I often tell clients, you'll learn more from me in a day, than you'd learn from your child's treating doctor in a year, because of not having the constraints of the politics of saying something wrong to a patient. Not that I would deliberately mislead my client, but I can speak more freely, and I can say, well, this is really what's going on. They're probably scared to say this. And it's all filtering that information in terms of what people are thinking about when they're thinking about, do I want to hire a lawyer, right?
So I don't want to overstate this and I don't want to put words in your mouth, but you basically just said that the doctors don't tell the whole truth to their patients.
I think that's pretty well established at this point. And some of it is very subliminal and subconscious, and it's through years of conditioning. I said to you, if I were to write a book, I've contemplated the idea of being the title, the 3 most dangerous letters in medicine. And those 3 letters being HIE, which is hypoxic ischemic encephalopathy, which without question is, I see it in an intake, my little antenna, they go way up. Because I think in modern medicine in 2022, no child should ever be diagnosed with HIE. And it's a totally avoidable condition. And I know that. Risk managers know that. They hold these seminars for the physicians in their hospital. Lots of doctors are in tune with the politics and the intersection of the legal community and the medical community. And they don't want to say it. So I'll often say to a client, I'll use a medical term, something very simple, and they'll say, oh, no one ever told me that. And it's stunning to me, where it's something that the phrase appears in the medical records 84 times, but the client has never heard it. And I believe it's true because of this overly political, overly concerned, am I going to say the wrong thing? And ironically, a lot of healthcare institutions have studied the effects of being cryptic and not being transparent. And it actually has the opposite effect. It breeds distrust. It means a patient is more likely to call a lawyer. And so if there are any healthcare providers out there listening, even if you think you've done something wrong, just be honest with your patients. It may avoid them coming to me. So I'm happy to give that tip. I'd rather the patients get good care.
Have you read the series of books, Sorry Works? Have you seen those books?
I've seen them. I haven't read them, but I know the context. And I think it's a philosophy that I think there is science behind it that is valid.
Well, and it's interesting you bring up HIE, because I think that that's a term that intentionally doesn't get said to people, because so often, and we've seen it, my office and your office just had a case where it was whole body cooling, and they didn't know the term HIE,
right?
And it was all over the medical record. So I think that one in particular, I think they're probably taught to stay away from. I don't know if you agree with that.
I definitely agree with it, and not only that, I think that there has been a deliberate attempt. Some of this, I'm implying that it's more nefarious than maybe it is, but I do think it's deliberate. There has been this attempt over the past 5, 6, 7 years in particular to stop calling it HIE and to instead call it neonatal encephalopathy.
Mm-hmm.
And to take out, at least for me, the only reason I see the medical community doing that is medical legal implications. There's no good medical reason to do it. There's no downside to whole body cooling. And so why would you ever want to take away the opportunity for a baby to be cooled by calling it neonatal encephalopathy as opposed to hypoxic ischemic encephalopathy? It's a distinction that just reeks of we're concerned about legal implications more than patient safety, which should disturb anybody.
Right. Absolutely. Coming back to the numbers, where do the numbers take you from here? Where do you want to go? I mean, where does Wais, Vogelstein, Forman, Koch, and Norman see itself in 10 years?
I like the size we're at. I think I think we're at a good number. I think any more, it gets a little dangerous in terms of that variance I was talking about, keeping that list at a certain number. Again, we get into this discussion of there are only a finite number of cases. There are a lot of great law firms out there competing for these cases. So I like the growth we're at. I'm not so sure I'd like to see us grow anymore. With one exception, I think the Chicago office, and in fairness to what I said earlier, because of the particulars of a certain jurisdiction, the Chicago office, we are doing a lot more general med mal than we do elsewhere. Not enough. I mean, that's kind of where that 5% comes in.
Got it.
So I like where we are. I think we're well positioned. We've got an incredible team of lawyers working. The young lawyers in my office are incredible.
Yeah. And as somebody who co-counsels cases with you, I can speak to that firsthand. Good people too. I mean, it really, to a person that I've dealt with in your office, good people. And you use the word blessed, and I think that's true. What else do you want to tell the Law by Number listeners, if anything, before we conclude?
Wow. That's like an invitation for a lawyer who likes to talk to just rant about something. No, I mean, I just think the quality of the work is what this is all about. I'm not one to shy away from the fact that we run a business, and that's a part of it that I enjoy. But it's just the quality of the work and making a difference in people's lives. There are a lot of injustices in the world, and people with disabilities are still marginalized today. And a lot of our clients come from means that are not satisfactory. And this has been studied too. There are certain demographics that just get marginalized the whole way down the line. In some ways, the Byram case is the shining example of that. Marginalized with her medical care, marginalized really at the trial level with the way the defense treated her and her case, marginalized by our appellate courts, never really got a fair shake any stretch of the imagination in any phase of that. And everybody should feel that a child who's been injured as a result of a hospital's negligence should be entitled to get justice without bias. And that's my speech on that.
I think it's great. One other thing I neglected to ask: what does the average case value need to be to really take care of a child? And I know this varies. I know this is all over the map, right? But like, what is the average case value in a birth injury case need to be in order to properly take care of that child?
So it's a really wide range, but $5 to $20 million, depending on the severity of the injury. And obviously, like everything else, it's on a spectrum. It depends on the facts of the case. It depends on the age of the child when the case is filed. A whole host of factors.
Got it. Keith, thank you.
Thank you. This has been exciting.
Yeah, no, I always enjoy talking to you. And I think Law by Number listeners are going to, really enjoy hearing what you've had to say and about your firm and about birth injury generally, about, about what it looks like to have success in a firm, because there's a lot of people out there who are a lot of attorneys out there who are trying to do good things, especially in the plaintiff's world. We get a terrible rap, but there's so many lawyers trying to do good things. And I just want, I want to bring them some information about how people have done it and say, okay, you can do this too. I mean, there's opportunity for everybody out here to do good for injured clients. So
Amen.
thanks so much for being here.
Thank you.